here to speak about something that's not on the agenda. Each speaker is to keep their comments period to 3 minutes to allow sufficient time for others. Comments are an opportunity to address the HRA, and please refer to the HRA agenda and minutes webpage for additional ways to submit comments. You can also call into the open forum by dialing 1-415-655-0001 and use the webinar access code 2633-377-8053, and the password is 1234. Is there anyone who's called in?
There is not.
All right, if anyone does, always let us know. Is anyone here to speak at the open forum? All right, seeing no movement. We'll move to approval of the minutes of the regular Housing and Redevelopment Authority meeting of December 18th, 2023, and the Special Housing and Redevelopment Authority work session of January 4th, 2024. Is there a motion for approval?
So moved.
Second.
It's been moved and seconded. Is there any comments, changes? All right, seeing none, all those in favor say aye.
Aye.
Aye. Opposed? The approval is passed. Takes us to item number 1, which is approval of the agenda. Is there a motion to approve the agenda?
So moved.
Second.
It has been moved and seconded. Any changes, comments? All right. All those in favor to approve the agenda, say aye.
Aye.
Opposed? And the motion passes. Taking us to item number 2, the consent calendar. Assistant Community Development Director, Urban, are you covering this one?
I am. Thank you, Chair Rees-Daniels, members of the HRA. The consent calendar contains separate items which are acted upon by the HRA in one motion. Once the consent calendar has been approved, the individual items and recommended actions have also been approved, and no further HRA action on these items is necessary. Any HRA commissioner may, however, request that an item be removed from the consent calendar and placed on the regular agenda for HRA discussion and action. All items listed on the consent calendar tonight are recommended for approval. There is one item, and that is consideration of a resolution authorizing the executive director to make modifications to the contract for private redevelopment with Nasadir Ahmed and Mohammed Issi for the development of 6326 14th Avenue South through the Richfield Rediscovered program. And that concludes tonight's consent calendar.
Okay. Is there a motion to approve the consent calendar?
I'll make a motion to approve the consent calendar.
Second.
It's been moved and seconded. All those in favor say aye.
Aye.
Do we have a discussion, please?
Oh, sure.
Yeah.
Do you want to move this off the consent calendar to have a discussion?
I mean, it's a very brief comment, and
Okay.
we only have one item, but if you prefer that, Chair.
Go ahead.
Okay. I just wanted to share comments that I shared already with staff for the benefit of the group. There was one aspect of this item that I wanted to comment on. It makes a note in the staff report that this alleviates concerns over the long driveway shown in the original plans. And I just want to reiterate from my memory of the discussion that the primary concern expressed was the fact that there was turf in the middle of the driveway as a means to reduce the impervious surface. I did not hear any general concern that long driveways were bad or that a front garage was preferable, which is what is now proposed. That said, it still meets our design guidelines and it still meets our zoning code, so I don't oppose the staff recommendation, but I just wanted to say I'm a little disappointed to go from a rear driveway, rear garage situation to front and center garage. I do appreciate some details of this design that minimize that effect. So, thank you.
Anyone else? All right, it has been moved and seconded. All those in favor say aye.
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 Opposed? The motion passes. All right, that takes us to item number 4, Assistant Community Development Director Urban.
And I am going to pass that item to our Economic Development Manager, Jan Youngquist.
Good evening, Chair and Commissioners. On November 20th, 23, the Housing and Redevelopment Authority approved a memorandum of understanding with Danny, Laura, and Mariela Jimenez. The MOU documents the intent of the HRA and the developers to explore the potential sale of the HRA property located at 1430 66th Street East and the consideration of financial assistance for development of a bakery and deli that would provide fresh baked goods to the 2 La Vaquita markets in Richfield that are partially owned by Danny and Mariela Jimenez. Under the provisions of the MOU, the developer's obligation is to work with an architect to develop preliminary plans for the project conduct a preliminary financial assessment, and present a preliminary proposal to the HRA by February 20th, 2024. The HRA's responsibilities under the MOU include refraining from marketing, negotiating, or contracting with another party for the sale or development of the property during the term of the MOU, which expires on May 20th of this year. The MOU does not obligate the HRA to sell the property to the developers. On December 19th, 2023, the United States Department of Labor and Industry filed a lawsuit against the ownership groups of the two La Vaquita markets, alleging that the parties violated federal wage regulations as part of the Fair Labor Standards Act. Staff notified the developers that while the lawsuit was pending, staff could not recommend that the HRA consider sale of the property or financial assistance for the project, because some of the parties named in the MOU are also named in the lawsuit, and the bakery intends to provide goods to be sold in the markets that are associated with the lawsuit. Staff recommended that the developers not expend additional funds on the project, but indicated that the HRA would honor the existing terms of the MOU regardless of what the developers decided to do. The developers would like to move forward with the project and have requested that the HRA consider amending the MOU to remove Danny and Mariela Jimenez from the agreement, which would leave Laura Pena Jimenez as the sole developer, and extending the milestone dates in the MOU by 3 months to provide additional time to comply with the obligations. Given the pending lawsuit and the uncertainty surrounding its outcome, staff has concerns about the HRA continuing to consider sale of the property and financial assistance for development of a bakery that would serve businesses involved in allegations of federal wage violations related to its employees. There is not an action in front of you tonight. We are looking for some direction from you, and so some considerations for you in the discussion. Would the HRA consider amending the MOU as requested by the developers? Would the HRA consider holding the property until the lawsuit is resolved? Or would the HRA like to terminate or allow the MOU to expire and market the site for redevelopment? That concludes my presentation. I'm happy to answer any questions, and Danny, Mariela, and Laura are in the audience with us tonight.
Anybody have any questions? Yes, go ahead.
Do we have any thought or indication what kind of a timeline we're looking at as far as resolving the lawsuit?
It's difficult to speculate, but from looking at other cases like this and discussions with our attorneys at Kenny and Graven, they've indicated it could take more than a year to be resolved.
Yes, go ahead.
As I understand it, the MOU will expire in May. Is that correct?
Correct.
Okay. And there have been certain timelines along the way that would have need to have been met by now. I think by today was one of the deadlines. So do we have any legal liability if we just let the MOU expire and do nothing and just continue and let it go on?
So, excuse me, so if the HRA is looking to part ways on this project, according to our attorneys, the lowest risk choice is to let the MOU expire. Based on what staff has shared with our attorneys, they're not aware of any grounds for a potential lawsuit if we do let the MOU expire. As a matter of the contract, the MOU does allow the right for the MOU to expire. The only sort of liability that the HRA would have is if the HRA did not honor its obligations prior to the expiration date of the MOU. And those obligations, again, are agreeing not to market, sell, or consider selling the site for another redevelopment.
Anyone else? Yeah, go ahead.
So to clarify, if the direction were that we agree with staff's concerns and we don't want to move forward, your preference would be to let it, just keep it as it is until May and let it expire then, or to terminate it early?
Our attorneys have indicated that they would prefer to let it expire under the terms of the MOU.
Okay. And what does it mean? I mean, they have not fulfilled, as Commissioner Young noted, they have not fulfilled the obligation, but it seems like staff also advised them to stop work on the process. So I don't know what that means.
Correct. So, in not knowing how you would like to move forward, preparation of architectural plans can be very expensive, and we didn't want, not knowing which way the HRA was going to provide direction, we didn't want them to expend funds, and so that's why, if you are amenable to amending the HRA, they have requested 3-month extensions to all of the milestone dates in order for them to fulfill the obligations of the MOU.
Okay, thank you. And then I'd asked this question in advance, and Assistant Director Urban gave a good explanation, but just for context, I know that especially on the council as well, we've heard concerns about labor issues in other contexts, including other developers the HRA has worked with. Assistant Director Urban gave a good explanation of why this was different from some of the other ones, like the accusations around 7700 Pillsbury and RF 64. Wondering if you could share those.
So there have been allegations of wage violations with subcontractors. So we work with a developer who works with a contractor who has a subcontractor. There have been claims, there's been allegations, there's been complaints. I think the difference in this situation is that there is a lawsuit that has been filed against the business owners. Now, let's be clear, the lawsuit has not been determined. There are allegations at this point, but it's something that we take seriously.
So I do think that it's fair to say that the HRA has said to the developers, don't spend any more money, because it is a very serious lawsuit. On the other hand, it's innocent until proven guilty, and so I don't want to make any judgments, because that's what the court system is for. So I would be comfortable with just letting it continue and letting it expire when we get to May. I don't think we need to make any amendments at this point.
And if I may, is it correct to say that if we continue on this path without making any decisions, that maybe the lawsuit is resolved in February or March? Well, February's running out. March or April, rather. And the potential developers can come back to us and say, hey, this has been resolved. We want to pick this up again, and then we could address it again at that point.
Certainly, if the property is still available for sale, they have every opportunity to come talk to us about potential development.
Okay, great.
Yes, go ahead.
I guess I just have a concern of, so if we were to we let it expire, we don't make any changes, like Commissioner Seppel mentioned, like we're kind of just treading water for nothing for a few months. Because we're not giving them the extension they need to actually meet any milestones, but we're also not ending this early, right? Because they would not presumably be pursuing any milestones if we just gave you the direction to let it expire. So, I don't know, I guess I feel like that's sort of an in-between thing that both potentially wastes time and also doesn't allow the developer to advance. So I feel like if we are thinking innocent until proven guilty and we want to give them a shot, then I guess I would probably prefer to do the extension that they've requested, because otherwise we're just wasting the next 3 months.
I agree with, we're not lawyers, or I'm not a lawyer, certainly, to make that decision. And I think allowing time for the lawsuit to happen and see what happens with resolve of that, I think is important. And so I would recommend, one, not making any changes. I don't want to extend another 6 months, knowing this could be longer. I think like maybe we can revisit it when it does expire, but I would be preferable to allowing it to continue as is.
I would concur with that. I don't know that another 3-month extension gets us anywhere if this could take a year to resolve. And likely, I mean, if you play this out, that lot is likely still to be sitting there vacant and ready for development in June, July, August, September. And we would happily reengage if the lawsuit is resolved. Because we haven't marketed it, we don't have anybody else interested. So it's probably going to still be sitting there.
Gordon? Yeah.
Well, I would also agree. I'm probably in favor of kind of staying the course, letting the MOU expire in May, and then letting the lawsuit play out and see where we are, at that point.
So again, just to be clear, it seems like there's consensus, except for me, which is fine. But what are we, so we're just gonna we're not gonna expect them to meet any of the deadlines because they've already missed one. We're not gonna terminate it early, and we're not gonna allow them to extend the deadlines. Nothing will happen on this process, but we won't do anything for 3 months, right? Is that what I'm hearing?
I guess I'm not of the, yes, one deadline was missed, but
Well, I guess, do we expect them to start meeting deadlines from this point on as they would have under the MOU, or are we, as staff first suggested, telling them to not do anything?
I think I would leave that up to them to make decisions about whether they're, wanting to continue or not. I appreciate staff's recommendations, but I don't think that we can say.
Yeah, they're closest to the litigation, and if they feel like the litigation is going favorably in their direction, they could start to spend money and try to come back and meet some of those deadlines. I don't know how we would predict that.
Okay.
Is that enough? I know there's nothing we're voting on or just
Right.
really kind of discussing at this moment, so does
So
that give you
what
guys
I'm
enough
hearing is
direction?
excuse me. What I'm hearing is you'd like to leave the MOU as is, and let it expire in May, and we'll see how things happen with the litigation.
Chair, if I may, I just want to clarify, make sure we understand that you are not interested in proceeding with them until the lawsuit is resolved. That's what I'm hearing.
Yes, I
Yes.
don't think we can make a judgment about that lawsuit as this body, so.
But it's important to us that it be resolved before we move forward.
Agreed.
Correct.
With anything new. Yes. Any other discussion, comments? Do you guys feel solid with that? Do you need any more discussion from us?
No, that's
Okay.
what I was looking for. Thank you very
Great.
much.
Thank you. That takes us to item number 5, HRA discussion items. Is there any other HRA discussion items? Yes, you always have a.
Well, I just wanted to say congratulations to Commissioner Hanson, who has just been reappointed. I think we'll officially start your term next time, but just wanted to say congratulations.
Great, well, thank you very much.
Congrats.
Congratulations.
Welcome back. Yes, go ahead.
I'll just give a heads up, there was a bill introduced today, I'd already shared it with Commissioner Supple, but HF 4009, which as a city we might have concerns about, but it's a state preemption bill related to housing, but were some version of this to go through, it might in fact open up new opportunities for us as an HRA, so it would be a significant bill basically requiring everything within a half mile of a transit stop to allow missing middle density and ban parking minimums, which is already addressed in another bill, and then also allow fourplexes, or, anyway, there are increased density requirements potentially in all cities, so this was, it's a stretch of a bill, but I will say it had a strong coalition of supporters, including our own Representative Howard, so definitely worth keeping an eye on and following, and again, with my city hat on, I have some concerns about what's proposed, but with an HRA hat, I don't know, potentially we could get more out of our properties if something like this passed.
Looking at the map, it says if you're within, I think, half mile of a bus rapid transit line. Well, we have 2 of them going through the heart of Richfield, so it's most of Richfield would actually fall under this.
Yeah.
Would that be the D line and the orange line? Is that
Yeah.
what you consider? Okay. Thank you. Yeah, most of which is within. Interesting. Okay. Anything else? Any other? All right. Executive Director's report?
Thank you, Chair Rees-Daniel. One of my items was to say that Commissioner Hanson had been reappointed, so thank you for that. We will swear you in next month. The second item is I met with MWF Properties, which is the developer that we had an agreement with for the development of 7700 Pillsbury with an all-affordable workforce housing development. They had gone in for tax credits. This was the third time this last year, and they actually went backwards. Their first two times, they were 1 point shy of getting funds, so felt it was worth going for it again. They, in both cases, improved their application, increased their points. In this case, they were well out of the points. There were over 90 applications for tax credits this year. And so in talking with them and they looking at the points that everyone else got and what they could possibly do to improve their application, they've determined that it's just not worth going back in for that site. So it's a disappointment. It was really helpful to meet with them. They have a really good understanding of what's called the Qualified Allocation Plan and how that scores applications for different communities. And so I have a much better understanding of sort of where we do well and where we don't do well. So I think that can be helpful, but it is disappointing that we will not be moving forward with that project at this time. So, and it's too fresh to know at this point. At some point, you know, we will talk to you more about housing affordability strategy. It's part of our strategic plan, and then also, you know, what we do with that property, but it's too soon to know yet.
Is that the old city garage site?
Yes,
Okay,
yep,
thank you.
where the office part was, yep.
All right. Is there a motion to approve claims?
Yes, so moved.
Second, anyone?
Second?
All right, claims have been moved and seconded. Any comments, questions, concerns? Seeing none, all those in favor say aye.
Aye.
Opposed? And the claims are approved. That takes us to adjournment for the HRA. We'll move on to the EDA in 1 second. Anyone need a break? No? Good to start? All right. We'll call the Economic Development Authority meeting of Richfield of February 20th, 2024. It is 7:22 p.m. This is time for the open forum. So if there is anyone here to speak at the open forum, each speaker is to keep their comment period to 3 minutes to allow sufficient time for others. Comments are an opportunity to address the EDA. Please refer to the EDA agenda and minutes webpage for additional ways to submit comments. You can also call 612-861-9764 or email ldubois@richfieldmn.gov with questions. You can call into the open forum by dialing 1-415-655-0001 using webinar access code 2633-377-8053, and the password is 1234. Anyone calling in?
There's not.
Someday someone's going to call. Thank you. All right. Is there a motion for approval of the minutes of the regular Economic Development Authority meeting of October 16th, 2023?
I'll move approval of the minutes.
Second.
It has been moved and seconded. Any comments, questions, concerns? No? Seeing none, all those in favor say aye.
Aye.
Opposed? And the minutes are approved. Takes us to item number 1, which is approval of our agenda. Is there a motion to approve?
I move approval.
I'll second that.
It has been moved and seconded. Any comments, questions, concerns? All right, all those in favor say aye. Aye. Opposed? And the agenda is approved. All right, item number 2. I'll toss it over to Assistant Community Development Director Julie Urban.
It is a mouthful, isn't it? I'm also acting executive director.
There you go.
So take your pick. And I'm going to ask Economic Development Manager Jan Youngquist to present the staff report. Thank you.
Good evening again, President and EDA Commissioners. Since 2020, the EDA has partnered with the Center for Energy and the Environment to administer the Richfield Energy Efficient Business Rebate Program. The program provides a rebate for Richfield businesses that complete upgrades through the one-stop efficiency shops, lighting, HVAC, or refrigeration programs offered by CEE. The program provides a rebate of 20% of the cost of qualified upgrades up to $2,500. Businesses making these improvements are also eligible for additional rebates from Minnesota utility companies. CEE receives funding from the utility companies to assist businesses as part of their incentive program, so CEE does not charge the EDA for the service. CEE works directly with participants, provides an energy assessment report, and completes all rebate paperwork. The EDA issues a rebate directly to the participant after the eligible work has been completed. In 2023, the program provided over $15,000 in rebates to 9 recipients for energy efficiency improvements. Since its inception, the program has funded nearly $70,000 in energy efficiency rebates. That concludes my presentation. I'd be happy to take any questions you may have.
Great. We'll start with a motion and then maybe do questions. Go ahead.
I'll move to approve a memorandum of understanding with the Center for Energy and the Environment to provide professional services related to the administration of the Richfield Energy Efficient Business Rebate Program.
Is there a second?
Second.
All right, it has been moved and seconded. Anyone have any questions or comments? Yes, go ahead.
So I had a question. I was looking on the staff report under the financial impact, and it says a modification was made to the MOU indicating that eligible participants are businesses or commercial property owners operating on property tax paying parcels. So that would exclude nonprofits, or that was my question.
So we took a look at the recipients over the past few years of the program and had noticed some places of worship and schools that have received rebates. And because the funding for this program comes through taxes and is to support businesses, we spoke with our attorney at Kennedy and Graven, and it seemed best to indicate that it would be on property tax paying parcels. I did take a look at various nonprofits in non-tax paying properties in Richfield, and they were primarily schools and places of worship. So Ark Value Village, a nonprofit, received rebates. They rent their space, and so they are on property tax paying property.
Okay, so it strictly depends on whether or not the property tax is being paid or not.
Yes.
Okay, I think that's a good change. I was just wondering, you know, we just did our policy for the SAC and all of that kind of stuff. Our future policies, are we going to consider putting that into the wording, or is this just a one-time thing?
Yeah, we certainly can consider it. It was just having looked at how the program had functioned in the past, and it kind of really jumped out that, you know, that funds had not necessarily gone to businesses.
And I agree with the change. I think it was a good policy change, so I just wanted clarification.
Sure.
Thank you.
Thank you.
Anyone else? All right, I'll just say I think this is a great program, and I'm happy that we can continue to offer it, and especially as, you know, Richfield ages in our buildings, and being able to upgrade this efficiency. It's a great program to inspire people to do that, so thanks for continuing. All right, all those in favor say aye.
Aye.
Aye. Opposed? And the motion carries. That takes us to item number 3, EDA discussion items. Is there any EDA discussion items? All right, seeing none, Executive Director's report.
I have no report this evening. Thank you.
Item number 5, claims. Is there a motion to approve claims?
So moved.
I'll second.
It has been moved and seconded. Any comments, questions, or concerns with the claims? All right. Seeing none, all those in favor say aye.
Aye.
Opposed? And the claims are approved. And that takes us to adjournment. It's 7:29.